Welcome, everyone. We're so glad to see you here on this sunny day in July. And we remind you that we have our speaker with us today. His name is Kris Goss, and he is the director of the library at Helena College of the University of Montana. Kris, you'll have to correct me if I know the name has kind of changed from time to time, but it's great to have you here in Helena at the Helena College Library. We are going to be talking about patron behavior and safety policies today. And along those lines, I just want to remind you that our opportunities to learn together are funded by the Institute of Museum and Library Services. Everyone is muted, and we encourage you to use the chat feature to ask questions and to discuss with other attendees. I will share an evaluation link towards the end of our time together. And as always, we appreciate your very honest and open feedback. As I mentioned, Kris Goss is the director of the Library Learning Hub at Helena College of the University of Montana. He is also an attorney, and we are so grateful again to have Kris working with us to do a series of legal topics webinars that are all very timely, but also very interesting as we seek to improve our practice and to make our libraries places where people know how to behave, they know the consequences, and they know how they can move about in our space and interact with our services. So with that, Kris, I'm going to stop sharing and I will turn it over to you.
Thanks, Coley, and thanks everyone for joining us today for this timely and timeless topic of managing patron conduct in your libraries. It's important to note that this is geared mostly for public libraries. School libraries, academic libraries, special libraries will likely have policies that are adopted by the board of trustees of that school district or by the administration of that university or college. And so it's important to be mindful of those expectations and those requirements within your particular institution. But within a public library, we're going to be discussing these patron conduct expectations and safety expectations for those patrons. And some of these themes will be able to be translated to a school district or college policy, but a primary focus in these situations on public libraries. And our goal is to again help build a foundation of knowledge for library staff, library directors, library trustees. So when you're interacting with patrons, when you're interacting with local government policymakers, local government leaders, you know the right questions to ask, you know the right topics to raise, and the right ways to address those topics to help address emerging, ongoing issues, but in a way that is knowledgeable so that you have the confidence to bring about the necessary change to a policy or enforce it in an appropriate way. The topic of patron conduct stems in many ways from a decision from the Third Circuit Court of Appeals and in the early 1990s in Grimer versus Police Bureau of the town of Morristown. And what we saw in this decision that serves as the basis for much of our understanding of patron conduct is that the First Amendment, as we talked about in our first session in library legal topics, the First Amendment to the United States Constitution inherently includes a prohibition on any government attempt to restrict or otherwise limit access to information. And unless there is a compelling state interest to limit that access, the First Amendment means and gives each American citizen that right to access information. Now, we know that this is a constant area of attention and that there may be emerging case law placing that issue back at the forefront. and emerging from a recent decision in the Fifth Circuit Court of Appeals. But as we currently understand and currently know the law from the United States Supreme Court, as we talked about in PICO and other decisions from the United States Supreme Court, there is that right to access information inherent within the First Amendment. Just as someone has a right to speak, someone else has the right to hear, listen, and receive information. So that right to receive information, the right to access information, stems from the ability to go into the library, review information, review materials, and receive library services. But that right to access information also comes with responsibilities, and how someone exercises their rights under the First Amendment to the United States Constitution also comes with the responsibility to um, conduct oneself appropriately within the public forum where you are receiving information, and that public forum in this situation being the library. If you go back to our first session again on library law, the different types of public forums, the traditional public forum being the sidewalk, a public sidewalk, the designated public forum, and a government area that has been set aside or designated for the exchange of information and the receipt of information. And so the court, the Third Circuit Court of Appeals in this case, found that the public library is a designated public forum. And as a result of it being a designated public forum, there is authority within the government, the library operation, the library board and staff, to place reasonable standards of conduct on patrons visiting that library and being the patron accessing information within that designated public forum. And so because it's a designated public forum and not a traditional public forum, the reasonableness standard is the standard from which we would review any rules that are promulgated by the library board or by the library as an entity, as a government entity, in order to manage patron conduct. And so that comes back to the compelling state interest. The compelling state interest to manage patron conduct is based on a reasonableness standard. And so in this decision, you can see that what the court specifically stated is that you have to have rules that come back to the mission of that library. The rules are tailored specifically to help the library achieve its mission, honor its mission. And in those situations, the library's rules have to be able to be consistent with that right to access information, but also consistent with the government's, the library's role in providing information, so that if there is any interference with another patron's right to access information, then that patron that is interfering with that right could have their right to access information curtailed or disrupted because they have violated those basic expectations of conduct. And so you see that direct quote there: other activities need not be tolerated, other activities being those that are not consistent with the library's mission and not consistent with the operations of the library and the effective operations, efficient operations of the library. So making sure that each patron can exercise their First Amendment right to access information ensures that each patron has those responsibilities to do so in an appropriate and reasonable manner consistent with the library's mission. One patron's right to access information does not prevent another person from seeking and enjoying exercising those same rights. You have to balance everyone's rights, each patron's rights, against the other, and with the obligation of the library to meet each patron's information or library services needs. And so that's where a designated public forum and the finding that it is a designated public forum is so important, because it sets those expectations for a government to set reasonable standards of conduct within the library or on library property or during library services. And we'll talk about how to establish those reasonable rules in a way that can be consistently enforced in a non-discriminatory manner without regard to viewpoint, without regard to membership in a protected class, in order to ensure the safe and efficient operations of the library. So that's the decision that much of our understanding of patron conduct policies stem from. And it comes back to that First Amendment right to access information, but also the understanding that the library is a designated public forum established by the government for purposes of information exchange. And so in an article, maybe 10 years ago in Library and Archival Security, the author summarized the findings in this decision by saying, yes, there is a First Amendment right to receive information. It is possible to violate someone's First Amendment right to access information if they are arbitrarily expelled, if they are removed from the library or otherwise restricted from accessing library services without a sufficient basis. If that basis is a violation of a reasonably established policy, then it is not a violation of their First Amendment right. But the policies have to be written in a reasonable manner and enforced in a non-arbitrary way. And they have to meet those expectations of the First Amendment right to access information. There may be imposition of rules and expectations about time, place, and how those conduct expectations affect library operations, but they're not going to be based on discriminatory factors. They're not going to be based on retaliatory factors or speech viewpoint factors. It has to be about the efficient and safe operation of the library, consistent with their First Amendment rights. There must be a right to appeal a decision to remove or restrict someone's access to the library to a higher governing board, and that has to be embedded within the policy. The rules have to be tailored to the mission of the library. The mission of the library is the foundation. It's the operational North Star, so to speak, of that library as an institution and as a government entity. And so any policy has to be consistent with that mission and support that mission. It is in the library's interest to adopt a patron behavior policy because you're never going to be able to prevent someone from bringing a complaint against the library. But what you can do is put yourself in the best position to defend against that complaint by having a library policy that meets the standards that are understood to have existed within the First Amendment and within the rights of citizens to exercise their First Amendment right. So you have that summary there. That's a 9-point summary that summarizes in a non-legal way the findings of the Third Circuit Court of Appeal that were not reviewed by the Supreme Court. The Supreme Court felt that the Third Circuit decision was in order and there was no need for the Supreme Court to review it. So that provides us with that summary and provides us with that guidance on how to adopt and implement a patron behavior safety policy. And so the summary that you see at the bottom is making sure that that reminder of you're not going to impose rules on the basis of discriminatory factors. We have those factors listed in the Montana Human Rights Act. They're also found to have existed in various federal and state court decisions in issues related to race, creed, sex, sexual orientation, religion, housing status, military status, family status, disability, political party, or any other protected class that may emerge through regulation or through court decision. You have an expectation to impose patron conduct policies in a non-discriminatory way. And that's vital because at the point where the policy is selectively enforced or enforced for discriminatory or retaliatory reasons or in an arbitrary manner, then the library is at risk of having a finding that it has engaged in enforcement of the policy that is inconsistent with someone's First Amendment right to access information. So you're in a better position to withstand a challenge by having these expectations detailed in a policy, and then having the staff trained to enforce the policy in a non-discriminatory manner. So with that understanding of the federal case law and the understanding of the First Amendment, we look at some Montana statutes that apply to each citizen within Montana, each person within Montana, for basic expectations of conduct in public. And these are embedded in the Title 45, which is the criminal code, Montana Code annotated. And you look at section 45-8-101, disorderly conduct, and you see the list of items there that a person can commit, engage in order to be found to have committed the offense of disorderly conduct. Knowingly disturbing the peace by quarreling, challenging to fight, fighting, making loud or unusual noises, using threatening, profane, or abusive language, rendering vehicular or pedestrian traffic impassable, rendering the free ingress and egress of public and private places impassable, disturbing or disrupting lawful assembly or public meeting, transmitting a false report of warning of fire or other catastrophe, hazardous or physically offensive condition by any act that serves no legitimate purpose, or transmitting a false report warning of impending explosion in a place where its current occurrence would endanger human life. So you can see the theme there. When someone engages in behavior that affects other people, that affects the orderly operation of society, or affects the ability of other people to enjoy their property or enjoy their surroundings consistent with their rights under the Montana Constitution and their rights inherent as a human being. And so that's where you can see that theme emerge, and using the disorderly conduct statute as a guide when developing a patron conduct statute can be very useful, because it shows that the conduct expectations have the support of the state law on reasonable conduct for a citizen in Montana. Section 45-7302, not as often looked upon, but there are components here that I think are important. Obstructing a police officer or other public servant. And the person can commit the offense of obstructing a peace officer or public servant if the person knowingly obstructs, impairs, or hinders the performance of a government function. And so you can consider each library staff member and each library board trustee as a public servant as defined in the law. They are public employees. They are appointed or elected officials in those situations where a board is meeting or a meeting with the county commissioners. You can see that as a public servant as defined in law. And if a person were to interfere, disturb, obstruct, impair, hinder the ability of that public servant to perform an official government function, then there is another statute that supports the potential prosecution of that individual. And so using that statute as a guiding point for developing a patron conduct policy is also very useful. And so those are two statutes to keep in mind when applying the lessons from the Morristown, New Jersey case into a Montana-focused library patron conduct policy. We blend those two together in order to build the policy. When looking at a patron conduct policy, there's some fundamental items to take from all of the different laws and best practices that we know about. That sound library patron conduct policy is there to ensure the library can be enjoyed by everyone. Each citizen, each community member, everyone has that right under the First Amendment to the Constitution to enjoy the library that their community is providing to them, and access the information, access the services within that library. And the library's policy is there to ensure that, and it's there to operate that library for the enjoyment of anyone who wants to access it. It's adopted in a way that is supported by law, so that the decisions made by the library staff are supported by the law. If there is ever a question from a patron or a question from a patron's advocate that they've been improperly restricted, from accessing the library or limited in their access to the library, the library staff members' decision can be supported by the law, and it's written in a way that is consistent with our understanding of the right to access information. So, balancing the rights of each patron with the obligation of the library to manage and provide a safe and useful, accessible facility. And so that balance is critical, and that's why legal compliance is going to be based on not just the laws that we've discussed, but also your specific layout of your facility, where the doors are, where the windows are, where the computer terminals are, where the books are, where the desk is. You can tailor the policy to make sure that your patrons' conduct expectations meet your specific facility needs and specific community needs. There may be specific community expectations through an adopted city ordinance or other municipal code that you would need to honor when developing the policy. So tailoring it to meet those specific needs is important. But it allows the staff to make efficient decisions in real time to preserve the library setting so that each patron can enjoy it. And if someone is disrupting that or interfering with another person's right to access information and interfering with their right under the First Amendment, then that patron could be excused from the library, and the policy would be enforced by the staff member in order to preserve a safe and welcoming setting. And that decision then is legitimized through a policy grounded and based in the law. So that's our goal when developing a policy of this nature. Specifically, with those understanding of those fundamentals within the policy, you have specific components that you want embedded within the policy. It should state or rely upon the mission, reference the mission that's adopted by the library board that appears in the strategic plan or appears on the website. That mission, as we saw in the Crimer case, is there to guide the development of the policy because any aspect of the policy has to be there to support that mission. And so the mission of any library is going to be three-pronged. A patron right to access information, a staff obligation to operate the library, a board obligation to establish a safe and appropriate library setting. If you have that embedded within your mission, then your policy details are going to support that mission. And as long as they're reasonably related to that mission, then those expectations for patron conduct can be effectively and efficiently enforced. So an example, imaginary library, the Mosaic Public Library serves each member of the community in welcoming, secure setting as they pursue their lifelong learning goals. What have we established? We've established that we want a safe and welcoming, secure setting. We've established that we're going to serve each member of the community, and we're going to help them with their personal lifelong learning goals as they access library and information services. You have that set out there, and then the details within the policy are geared to help the library board and staff meet that mission for each member of the community. The next component of a policy that's very important is authorizing the staff in delivering services, maintaining a secure setting, and then enforcing the policy. This would likely be through a reference to another policy that you have on authority of the director or reference to the job description for the staff members. However it's developed, you have that either listed in the policy or cross-referenced to another policy in order to have that specific authorization for the staff to implement and enforce the policy. If there's a policy that authorizes the staff to take action, then the staff are specifically protected under state law from allegations that they have engaged in some kind of misconduct or that the insurance coverage doesn't apply to them. And so Having that specific authorization is in the library's interest to protect the staff and ensure that the staff is operating in a manner that isn't permitted by law, but also within um, the board's authority to delegate and authorize those specific actions. So our goal in that case is to meet that need of having the staff with a specific authorization to take action if the policy is violated. Another aspect of the policy then is the list of prohibited conduct. But that list is not going to be exhaustive. You cannot anticipate every little thing. I'm sure every person on this call has a story that would shock non-library staff people, but when telling stories to other librarians, to say, "Oh yeah, I've seen something like that." And people are always going to have strange behavior. And that's just a human nature. And so you're not going to be able to list out every potential violation of a patron conduct policy. There are general themes that you can capture in a series of prohibited statements, statements of prohibited conduct, but the um, the important aspect is to have um, a catch-all, a general statement that includes prohibition on conduct that interferes with the staff's ability to operate the library or interferes with the rights of other patrons to enjoy the library or access information services. So you're never going to get an exhaustive list, but you're going to build a policy that captures as much of it as possible, whether anticipated or not, so that you can look to the policy and say, that conduct may not be listed here, but it still violates the policy because it interferes with other patrons' right to access information. It's reasonably related to the operation of the library, and it limits the ability of the staff to manage the library. So, with that understanding of the components, here's some examples of the prohibited conduct list. In an introductory statement that the conduct expectations for library patrons, first stating that we welcome all patrons to access information and library services. Each patron shall comply with staff directives and library policies to ensure other patrons may enjoy the library and library staff can complete their duties. To honor the library's mission and in compliance with applicable laws and policies, the library patron on library property shall not. And you can see the themes that we've taken from the case law and state statute on the issues of fighting, challenging to fight, injure, threaten to injure another person. Person shall not damage another person's property or the property of the library, violate any provision of the criminal laws of the state of Montana or any town or county ordinance, smoke, otherwise use tobacco, nicotine products within 30 feet of the library or inside the library. Some counties or cities may have different radius uh, outside the library building. You'll want to check that. I think 20 to 30 feet is a pretty standard item, but you'd want to check how that is, or you could list designated smoking areas outside the library. But that's one to keep in mind. The people entering the library facility, there would be an expectation that it wouldn't be interfered with through a gathering of people smoking by the entrance. And this along the same lines: consume, possess, distribute alcoholic beverages, illegal drugs, marijuana. The marijuana laws prohibit the use of marijuana in areas where smoking is prohibited, and smoking marijuana where smoking tobacco is prohibited. And so you can have reasonable expectations and standards for that type of consumption, within the library facility um, for that type of conduct and alcohol use, other illegal drugs can be restricted so that you have a safe setting for library patrons of all ages. And then impeding, delay, disturb, disrupt, otherwise interfere with the orderly conduct of the library function, including but not limited to delivery of library services, conducting a meeting in the library, or completion of the library's operations. You can see the way that that's structured is library services can mean a variety of different things that are completed by library staff. Same with completion of library operations. Those are completed by library staff. Conducting a meeting in the library, though, is something we've talked about with meeting rooms. It's not the library that's conducting that meeting. It's someone using the library's facilities for purposes of the conducting their own meeting. So if a person were to attempt to disrupt another patron's meeting that's being held in the library, that could be a violation of the conduct policy because it is a disruption to that patron's access of library services and access to they're exercising their rights under the First Amendment. And so it's not just the interference with the library's delivery of services, but also the access to those meeting rooms by other patrons. And then entering the library premises at any time for purposes which those are unlawful and are not authorized by the board. And then some discussion of weapons, which we'll talk about in a bit more detail in the next slide. But discharging a firearm or possessing an unpermitted concealed or unconcealed weapon or firearm in the library building. And those are taken straight from the state statute on weapons in public buildings that were recently updated a few years ago that provide specific guidance for local governments on the possession and use of firearms and weapons. And then using threatening, profane, and abusive language, again, taking a theme from the disorderly conduct statute, and then failing to instruct the security officers or a district or a library employee. In the case of a library or in the case of a school district, you would have that that provision there that allows the library staff to make those directives and to redirect an individual. And if they fail to honor that directive, that could be a basis for a finding that the library policy has been violated. So, and then you have that conduct that's there that captures the potential violations of the expectations of conduct by a patron in the library, but also relating each time back to the theme of supporting the library's mission, supporting the goals of having a safe and welcoming setting, and having those situations addressed by library staff and having the library staff authorized to manage those expectations. And then a definition of what library property is. That means the library's buildings, whether they are owned or leased by the library or the government that supports the library, whether it be the city or the county, and also including vehicles. If there's a bookmobile or if there's a car owned by the library and a transportation of staff to and from branches of the library, that if someone were to impede or interfere with services in the bookmobile or book bike or other vehicles, then having that established. And then if there's no other reference to the library building, which is the case for weapons as outlined in state law, then it could include the library's property, parking lot, and other areas surrounding the library that are used for library services, and including the designated smoking areas. So getting into that detail as to where the policy applies is also going to be important, because as we learned in the Crimer decision, that time and place restriction is appropriate as long as it's enforced in a non-discriminatory manner. I stated that we would talk about weapons in a bit more detail, and these are the statutes that the language, sample language is based upon. And it's two statutes governing the possession, use, of weapons, public grounds and public buildings. And there again in the criminal code 45-8-351 and 352. And so these statutes, as shown here, the portions, the applicable portions shown here. City, county, or town, consolidated local government, or other local government entity may not prohibit use of, or unconcealed carrying of any weapon in firearm, including those listed. But then subsection 2, for public safety purposes, city or town may regulate discharge of firearms. And then the second sentence, city, county, town, consolidated local government, or local government unit has the power to prevent and suppress the carrying of unpermitted concealed weapons or the carrying of unconcealed weapons in a publicly owned and occupied building under its jurisdiction. And so if we go back to the example, that's where it's a statement about the library building. The building is the key component of the statute because the building itself is what's stated in the law. And that same theme is utilized in 352, publicly owned building, owned, leased, or possessed by a local government entity. So it's the building itself where the prohibition can be applied by a local government entity. It cannot be applied to the property exterior to the building. In other words, the parking lot. But that restriction on unpermitted concealed weapons and carrying of unconcealed weapons, it can apply within the library building. And so that's the specific provision within the example that we discussed that would be utilized based on the law, as the law does not allow a local government to make those restrictions to areas outside of the building. The same applies to the discharge of firearms. That's specifically noted in the law, and that could be specifically noted in the policy without regard to being inside the building. Checking with your local government, the city ordinance, county ordinance, your partner local governments that support with the library and make those determinations. The city attorney or county attorney are going to be important as well. And the district, library district, or the county or city's insurance carrier, library's insurance carrier, making sure that your policies are consistent with insurance coverage so that there is not a gap in coverage because of language within the policy. And so having that all checked will be important, and using the law as a guidance for having those conversations and knowing with confidence what the law does provide. Maybe pause there. Are there any questions, Colleen, in the chat?
No questions so far, but we do want to encourage folks, if you have one, please put it into the chat and we'll circle back to it.
So we have the policy. We know it's based on the mission. We know it's based on the applicable case law and statutes. And then how do we enforce the policy? And enforcement of the policy, as we saw in the decision in the Third Circuit Court of Appeals, is important because it has to be enforced in a non-discriminatory manner. It has to be enforced without regard to viewpoint. It has to be enforced in a manner that gives the person a right of appeal of that decision, that their First Amendment rights are going to be restricted. It relates to that specific library. They have a right to appeal that decision. So some example of enforcement provisions. If there is a person who disrupts or obstructs the library operations, program, or activity, or meeting, or threatens to do so, or threatens to imminently commit or incite another person to commit any act that would disturb or interfere with the library, then the library director or designated employees are authorized to take appropriate action as circumstances warrant to enforce this policy, including but not limited to excusing the patron from the library building, event, or service, and contacting authorized personnel for assistance. That's a lot of words, but it's and I tried to not have the run-on sentence, and you may be able to break it down. But what it's saying is if you have someone who breaks the rules, violates the policy, threatens to violate the policy, causes someone else to violate the policy, then the director or the director's designee can take the necessary action to excuse that person from the library, building, or service or event, and then contacting the designated or authorized personnel, whether that's law enforcement or security staff or another support entity that the city may be providing for situations where there is a disturbance in the public. That's the first step, is to have that person removed from the situation or excused from the situation on at least a temporary basis to allow the library to restore order in its specific setting and allow the other patrons to enjoy the library setting and exercise their First Amendment rights. So in a situation where that person has been temporarily excused from the library for violating the policy or obstructing or disrupting the library's setting, then there needs to be a next level of consideration. And the director could then be authorized to restrict patrons from accessing the library or library services for a period of up to 1 year for an initial violation of the policy. That could mean they're not allowed in the library branch or the library building. They're not allowed to access the bookmobile. However, it's worded based on the details associated with the offensive conduct. And then that has to result in a written notice, if possible via certified mail, if the person has a mailing address, or personal delivery, if perhaps they don't have a mailing address. Then that decision and the explanation of that decision are provided to the individual, and that restriction then would be in place for the period noted in the letter, and that would then also result in a notification to law enforcement that that person has been restricted from the library, because if the person were attempting to re-access the library during the period of a restriction, then that could be considered not only a violation of the director's decision, but ultimately possible offense of criminal trespass, that they are no longer licensed to be at the library setting or the library event or that particular area of library services. They have violated that order that was made in a manner consistent with the policy and consistent with the law, and that can be its own separate, distinct violation, which could result in criminal prosecution. So notifying law enforcement of that decision and having channels of communication with law enforcement on these matters is important to help enforce the director's decision if there is a need to remove a patron from the library or restrict that access for a period of time. The restricted patron may request that hearing with the board to petition the ability to regain access to the library. That's the appeal process that is required or expected within a person's First Amendment rights to petition for redress of grievances. And so having that appeal process noted in the policy is very important. Hopefully it would never come to that, but repeated violations may result in extended and potentially permanent restrictions. And that would be an unfortunate situation. All of this would be unfortunate, but there are situations where that has to occur. If someone cannot honor the library's mission, excuse me, or honor the library's rules, then there is a need for the potential of that restriction to be extended. The appeal process would be laid out in the library's policy as well. The date, time, and place of the board hearing, the description of the violating conduct, and then the important piece from the library director and the library board a description of the process for the meeting. Whether there is a presumption of the public right to know about the patron's conduct and the public's right to know to observe that meeting, or whether there's an aspect of the patron confidentiality laws that would require a closure of the meeting, and how the patron may present information to the board for consideration, and how the board will consider that information, as well as consider the directives of the director or the staff with regard to the violating conduct. So having that laid out in the letter, you may take a step further in having it laid out specifically in the policy as to how those hearings go, and that there's a presumption that that the director's decision was appropriate, and that the patron has to demonstrate that the decision was improper, and having that explained in the letter, the process, so that you have some framework for the meeting, and it doesn't just devolve into a mess, which is quite possible in these types of situations. So those details are important. Having them explained to the patron in advance helps the patron better understand the process and hopefully follow the rules of conduct, rules of procedure during that appeal hearing. So having
Kris,
that all,
I'm sorry to interrupt. There is one question, and
yeah,
I think this is it's important frame of reference. So the question is, where does the 1 year time frame come from? I can think of even examples from my past where someone, a policy might say 3 months or have a progression of
sure.
periods of time. So where does the 1 year come from basically, or is there kind of a standard for the duration that somebody might be excluded from the library?
It's a great question, and the 1 year is phrased as being up to a year, so that there isn't a bright line standard that you would utilize. It's kind of a standard um, operation for local governments to have that initial restriction for up to a year, and you could clarify that, and we could adjust it to say um, for a period of 1 month, or a period of 1 week. That initial restriction shouldn't be more than a year, is maybe the better way to phrase it, because you start getting past a year, it starts to be a little bit more permanent without the essential due process, findings that are necessary for someone to have their rights permanently curtailed. So phrasing it as up to a year gives the flexibility to the director to be, you're out of here for a week, you're restricted for a month, you're not allowed back for 6 months. And you could go the full year. I think for me, the mindset that I come from in working with schools in the past is that suspension or expulsion from school a standard is up to a year. And so that, like I said, is a best practice or a standard for local governments. And if you were to go past a year, I think there's some elevated requirements, but for up to 1 year, gives the director flexibility to make a decision that could vary from 1 day to 365 days. So your policy could be different. It could allow for tiers. It could allow for um, certain types of conduct to result in certain periods of restriction. I would urge caution in developing that type of restrictive framework that may not allow the director to um, make decisions based on specific circumstances. And so being flexible and having it be up to a year allows for that. And you could clarify it to say it does not have to be a year. It could be any period from 1 day to a year, depending on the circumstances, and that could be adjusted to meet your library's specific needs. But so I think the 1 year period is just a best practice to use as a guiding point for initial restrictions that are placed on a patron's access.
That's great. Thanks.
Other questions? The Library Assistance Helpline is available at any time. We're there to help and provide information to any library that might need it. And however we can help, we'll try to get back to you as soon as we're able to provide that legal information that is designed to help you stay on the right path with the issues that are emerging in your library, and have the confidence to handle them with the information that's necessary to be responsive and to stay focused on library services instead of legal matters. So reach out at any time. We're ready to help. Those emails come right into my phone, and we get back to you, like I said, as soon as we're able. Are there any questions about any of the topics that we've discussed today on issues related to designated forum, patron conduct, restrictions on First Amendment rights, enforcement of the policy in a non-discriminatory manner? Anything that you were hoping to hear that we didn't cover?
I am hearing and seeing none in chat, and just to give folks a little bit of time to think and maybe formulate a little bit more, just want to remind you of the upcoming webinars. And we have quite a nice series as we're going forward from this week. And let's see here. Also, I will put this link in the chat, as I said, for the evaluation. And now we do have a question, Kris. And so and Sherry's just put in the topic of patrons with dementia. So is there any sort of twist to policy that might deal with patrons who are diminished in their capacity or incompetent in some way? So Sherry's bringing up a specific example of patrons with dementia.
Yeah, that's a good question. And the patron with dementia or other different inabilities or differences in capacity, they wouldn't be excluded from the library because of that capacity issue or that disability or diagnosis. Instead, and this could be an issue with someone who may be diagnosed with any type of syndrome that causes random outbursts, or may have inability to manage their faculties or limbs, and that could be off-putting to other patrons, but it wouldn't be a basis to exclude someone solely because of that diagnosis. Instead, if there's a possibility to work with the individual, their caregiver, their advocate, in order to ensure they receive library services in a way that is useful for for them considering their diagnosis, and that's difficult. There may be many patrons around the state that want to be in the library, utilize the library, but don't have a caregiver, don't have an advocate, someone that can assist the library. And so that takes a tremendous amount of patience on the part of the library staff in working with the individual. But if it becomes untenable, if it becomes unmanageable, and it is causing a disruption, finding a way to balance the rights of that individual with the rights of others, and helping that individual that may have that diagnosis access library services in an area of the library that minimizes the disruption, or handles the situation in a manner that still honors their rights without disrupting the rights of others is important. It comes back to that phrase within the statute that the individual is knowingly disrupting the public, knowingly disturbing the peace and engaging in disorderly conduct. Someone with diminished capacity or diagnosis disability may not knowingly be engaged in that type of conduct. And so in those situations, we seek to serve with compassion and finding a way to balance those individuals' rights with the rights of others in any way that can be creative or innovative to help everyone best use the library. So probably not the clear answer that you're looking for, but the clear and understood aspect of it is that the person would not be discriminated against because of their diagnosis.
I think that helps. And Kris, would you say that, I mean, this is a great example where the discretion of the director in approaching a difficult situation like this is really important.
Right.
Yeah.
Yeah, making sure they have that discretion and the designated individuals, the staff, team members have that discretion and how to do it so that if you had someone else say, can't we throw that person out of the library and just causing a disturbance, they're able to say, no, they have a right to be here. We're working to manage the situation, and thank you for your patience. And that allows then, if there were to be a complaint to the board that person, that the staff didn't throw the person out of the library, the board would say, no, we've authorized the staff to make those decisions consistent with our policy. And so that all works both directions, as you say. And then back up to Sarah's question on the 1 year. The 1 year would not be the maximum. Again, it's just a standard. If there were to be repeated violations, there could be extended periods that go beyond a year, but up to a year is, like I said, just an industry standard or best practice that helps give the discretion to the director on how to handle situations based on the specific circumstances.
That is very helpful. I just want to make sure if there are other questions that folks want to ask, this is your time. We have 3 minutes left in our time together. I will have the materials and recording posted later today, but okay. So Sarah says
Yeah,
homeless
that's a good
has a
reminder.
dementia-specific training that's available through your MLA membership. That's awesome. So
Good
do reach
reminder.
out and look at MLA offerings for that opportunity.
And then next week we have surveillance and patron confidentiality.
Yes, yes. I think that will be another hot topic, as is everyone in our series here. So yeah, I can't wait to dig into that topic a little bit more. And definitely those who are going to join us next week, be thinking of those questions, those burning questions to add to the hot topics. And feel free to send those my way or send them to Kris through the
Yeah,
helpline, and we'll have things prepared.
yeah. If there's anything, any of those topics that are coming up, we'll integrate them into the presentation. It's your specific real world examples can be helpful to me and to others as we navigate all of these emerging issues.
That is great. Well, with that, Kris, thank you so much. I think we'll wrap up our recording for today and look forward to our next session.
Thank you, everyone. It's great to see you all again. We'll see you next week.